All right, folks, buckle in. This hearing turns into a full-blown legal chess match. The defense wants the GPS monitor removed. The state is not having it. And the judge? Well, just watch how fast she shuts down any wiggle room.
Or there's possibility that she could be drinking. So that's what the state's main concern is.
All right. Is she on a ignition interlock?
Yes, ma'am.
Well, no, excuse me. Don't do that unless you're called as a witness. Does ignition interlock address that issue, or does it not address the issue?
Judge, again, the word is that the frequency of the DWI is the number it's at. An ignition interlock on one car doesn't mean that she's completely unable to get into another car. So that's why the state's concern for GPS is also to have that in place to have extra protection.
All right. So how will GPS show she's not in a vehicle, though?
Well, Judge, if she has any type of full house arrest or partial, we know where she is. We know what type of adverse what her movement's going to be. If she's not on GPS and we have no idea where she's going, she can leave her car with the ignition interlock there at home and then immediately get into a car that's not with the ignition interlock.
All right. So she has put in here, or at least there's a letter attached to the motion stating that she is helping someone go to their doctor's appointments. So do you have any objections to her going to doctor's appointments with someone?
To her, the doctor's appointments, no.
Yeah. It's to...
Pause right here. This is a classic tug of war. The defense thinks the ignition interlock is enough, but the state basically says, no, she can still find another car. And legally, they're right. Interlocks don't cover every vehicle, but GPS doesn't necessarily prove she's not driving either. It's fascinating how both safety and fairness collide in bond conditions like these.
Another person, Mr. Eloy Lopez. All right. First question, defense.
Yep.
Is this, the state has said that she has allegedly over 8 DWIs. Does she allegedly have over 8 DWIs?
That have been alleged, yes.
Okay. All right. So you've heard the state's concerns.
Well, I would like Ms. Cotner just to tell you why she needs to do this. Hey, Ms. Cotner, just explain to the judge why you need to get that off of you to help this gentleman. Why?
I am currently the caretaker for an elder gentleman by the name of Eloy Lopez Sr. And Mr. Lopez is 87 years old, and he has some cognitive decline, and he's recently I helped him recover. I administered drops and home recovery from 2 cataract surgeries. He loves me like a daughter now. I do everything. I feed him. I wash his dishes. I make sure that he does not have any falls. He uses a walker to get around, and he depends on me. And he cries and he really cares for me, and I'm enjoying and getting a lot of fulfillment out of helping this man because he genuinely needs this help.
And here's where the case shifts emotionally. The defendant paints herself as a full-time caretaker, cooking, guiding, even managing medical recovery. Judges do take compassion into account, but remember, emotional hardship don't erase public safety concerns. This testimony is heartfelt, but will it actually sway the court?
Hard of hearing, and when he goes to doctors or stores, I'm very gentle and kind with him, and he's not afraid to speak with me, and I can understand what he's trying to say rather than a stranger who might not be familiar with him might yell at him and try to understand what he's trying to say. I've been able to do that with doctors, nurses, and secretaries, etc. And this man loves me like a daughter, and I would like to be able to take him in an Uber comfortably and assist him at the doctor's office, at the grocery store where he can pick out his favorite groceries, which I provide for him.
All right. Why can't that be done with GPS?
Well,
No. She's on the witness stand. Why can't that be done with GPS?
Well, Your Honor, I've had no violations after 8.5 months on GPS.
No. My question is, why can't that be done with GPS?
Well, I have to put in 24 hours notice for any GPS needs, which I've been able to do successfully for any needs of my own. But Mr. Eloy Lopez sometimes thinks right at the moment. that he might need.
All right, State, with regards to her testimony, do you have any questions?
How long have you been employed by Mr. Lopez?
Since January of 2024.
And so far, you've had no issues reporting to probation or to pretrial any type of trip that.
Notice what the prosecutor just did, a strategic lock-in. By getting her to admit she has managed with GPS for months, they weaken her argument that the device is preventing her from caregiving. In courtroom chess, this is called tightening the narrative. Smart move.
You take to help him out. Is that correct?
Yes, sir.
So far, you've been able to accommodate helping him while also being on GPS.
Made it happen. It's been difficult, but yes.
Nothing further to say.
All right, any other questions?
Well, Ms. Codner, are you asking to be able to take him to other locations that you do not have access to right now?
Well, I have access to, what do you?
Well, in other words, you are in lockdown at home, correct?
Yes, sir.
Okay. And if he needs to go somewhere, you can't take him without permission. Is that correct?
Correct.
All right. Are you asking the judge to allow you to take him where he needs to go without having to contact pretrial services?
Yes, sir.
All right. So this is the court's suggestion. My suggestion is you all step back. I'm not going to remove GPS. The problem is, one, people in my court, I don't allow them to.
Boom. Major ruling. The judge draws a firm line. GPS stays. And here's the twist. She even notes that normally she doesn't allow defendants to be home health providers at all. That means the judge is already giving more leeway than usual. Instead of removing GPS, she orders both sides to create a structured schedule, a classic judicial compromise.
Be home healthcare providers, and that's what she's doing. However, she's not been convicted of this offense for the court, so the occupation is her occupation. I'm assuming, hopefully, that the family knows her history before they hired her. So I'm not going to remove the GPS. Y'all need to step back and work on a schedule. And that will be her schedule because she is on partial. So y'all work on a schedule that includes the person that she is caring for. And I would suggest that an address for that gentleman be included in this. Kelly Cotner.
Ma'am, what did you say?
All right. Now, so for this case, there were some officer records or something
Yes.
in state.
We're not going to sponsor that officer's witness.
All right. But the question is whether you are going to sponsor the officer or not. Did that officer have anything to do with this case?
Yes, he did.
She did.
So then the question becomes whether or not the defense is just going to accept that that officer is not going to be called as a witness, because maybe they want to call the officer as a witness. I don't know. So where are we on that? Have you all conferred over that?
Well, not over that. I mean, he's not somebody I would want to call with.
All right. So then do you need the records then? Since they say they're not sponsoring him as a witness, they're not going to call him.
That's correct. Now, because of that, there is a secondary officer that they intend to go forward with, who didn't make the arrest, who didn't make the stop. And I've got some motions I'd like to file on that.
Well, why? I mean, I don't understand why that hasn't been done. What motions need to be filed on that?
Well, I don't know that that officer can sponsor this other officer's stop and video when she wasn't even there.
I mean, well, that'll be something for you to take up at trial and see whether or not, and I'll make a ruling on whether or not that officer is allowed to testify. But whether or not that officer is allowed to testify, I can't make that decision unless you're actually in trial, because I don't know what the state's evidence is going to be. I don't know if that officer has any ties to this case whatsoever, tangentially or not. So that would be something that would have to be taken up at trial, whether or not that witness is relevant.
Well, there is an issue on the stop itself. But it is a video that was made by the officer that they're not going to sponsor.
All right. So what I'm saying is this, and I want everybody to hear me clearly to make sure that I'm communicating what I'm trying to say to you.
Yeah.
In a jury trial, witnesses will be called. I don't know anything about your case. The only thing I know is what you're charged with. I do not, and I'm not allowed to do a pre-jury trial where I hear everything and make decisions, and then people can then have a trial. So what will end up happening is the state will call witnesses. If there's a witness that the state intends to call and the defense thinks that that witness is not relevant, then I will make a ruling. If I determine that witness is not relevant, then guess what? That witness won't testify. For example, on your case, I know nothing about your case. Hopefully, Ms. Abrams knows nothing about your case. So if the state were to decide to call Ms. Abrams as a witness.
This is a straight-up legal masterclass. The judge explains in detail how witness relevance gets decided during trial, not before. She's basically educating both attorneys and the audience on how evidence battles actually happen behind the scenes. If you've ever wondered why trials take so long, this right here is why.
In this case that she knows nothing about, then you know what your attorney would probably do? Your attorney would probably say, Your Honor, I'm object to Ms. Abrams as a witness. She knows nothing about this case. Then you know what I will say? Ladies and gentlemen of the jury, if you'll step outside, we're going to have a hearing outside your presence. And then I will have your attorney to question the witness. He'll probably say, Ms. Abrams, were you at this scene? No, I was not. Do you know anything about this case? No, I don't know anything about this case. Then I will turn to the state and I will say, State, how is this witness relevant? And then if they tell me, well, she doesn't know anything, then guess what I will say? This witness is not allowed to testify. Ms. Abrams will step down. The jury will come back in. I will give the jury instructions and I will say, Ms. Abrams, the witness who was called, you're disregard any testimony that you've heard from her. It's as though she never even appeared. But I won't know if she knows anything about this case or not unless we're in a jury trial.
Well, then we do have some motion in limine issues on the case.
With the motion in limine, the way that happens, unless there is some legal reason that it appears that testimony or something cannot be heard, then I can make a ruling on it. But I can't grant motion in limine when I know nothing about the case. For example, the only way that I will be able to grant a motion in limine is, this is a DWI. Let's say somebody's saying you committed a murder also, right? That is unrelated to this DWI. With that, I can say that is not coming in whatsoever. But usually with motion in limine, it's different things where the attorney does not want certain things brought before the jury. And what I'll tell everybody is I'll say, look, state or defense, if the state has a motion in limine, I'll say, if you're going to get into the fact that she cut down Auburn's oak tree or whatever, I'll be like, y'all need to approach before you question that witness about that. And then the jury will go outside and then we'll talk about it. And I'll say, okay, what does her poisoning or cutting down the tree in Auburn have to do with this case? And again, if it has nothing to do with the case, I'll be like, it's not coming in. Or if I find that it's more prejudicial than probative, it's not coming in. But I can't make those decisions until I know what's going on with the case, because the only thing I know about your case is what you're charged with. I don't know any facts of the case whatsoever. I don't know. The only way I know about
Courtroom tension alert. The defense subtly blames the state for delays, but the judge shuts it down instantly. She wants motions filed today, no excuses. This is the moment you see a judge's patience run thin after a long, dragged out case.